Hi, it's Roland Jones. This is another video in a series on preference and fraudulent conveyance issues. This case involves a company that was in the business of buying and selling electricity, and Avista is the defendant in a preference action brought by the debtor. It's a 2015 case. The main issue here is whether it can be ordinary course for the debtor to make a payment right before bankruptcy in the 90-day preference period when it was in the business of closing down its operation, when it was in the midst of closing down its operations, or actually had closed down its operations. So the fact pattern here is that the energy trading business had ceased apparently buying and selling electricity, but for some reason that was not explained, made this purchase from the defendant, and so the trustee argued, "Hey, this can't be ordinary course. They're not doing business anymore. They haven't done business in a year. They did this one transaction, but they're not in this business anymore. So how can this be in the ordinary course?" The defendant argued, well, they paid according to terms, and they paid it just like they always paid. So they paid in the ordinary course between the parties. Conduct of the parties was consistent between the preference period and a comparison period. And the defendant also argued that the payment was ordinary for the industry. The sale of electricity was structured the way it normally is in the industry, and the payment was the same kind of structure. And so the question was, can a payment when a debtor is really no longer in the business it was in be in the ordinary course? I thought it was a pretty good argument by the trustee, given that it was the only thing he could argue, since it was almost the fact pattern otherwise was a perfect ordinary course defense. But I thought it was also a good argument because, or possibly a winning argument, because this company was no longer doing business. So how could the payment be in the ordinary course between the parties, or even for the industry? How many companies that are wound down or in the business of winding down make purchases of electricity? So it seemed to me to be a dangerous argument for the defendant by the trustee. This is the applicable section we're looking at, 547 C2A and B, although we're highlighting business terms because the court did address the issue of whether the industry standard defense was met by was successfully asserted by the defendant. Well, the court made some basic general observations, like courts usually do. The court accepted the defendant's argument. The court looked at the transactions, found them to be in the ordinary course of the parties, heard testimony by the defendant saying this is how it's done in the industry, and there wasn't any evidence contradicting that evidence. And so the court decided that whether the company was winding down or not is not enough to take it out of the ordinary course. Just one of many factors a court can look at. The plaintiff cited some cases where a debtor was winding down and the court found that the transfer was not in the ordinary course. But this court said those cases can be distinguished. That was just one factor among other factors. And In these other cases, the transfers had other indicia of not being in the ordinary course. But here, everything was consistent with an ordinary course defense, except that it was winding down. And the court found that not to be uh, uh, a sufficiently important factor to deny the defendant its ordinary course defense. So, good to know. Now, the court mentioned that in an industry standard defense, the court does not have to consider a baseline of dealings, but here the court did anyway, and just found that both prongs of the ordinary course defense apply, both the industry standard and the ordinary course conduct between the parties.